Hi, I'm David Freudberg, the host of Humankind. I actually grew up in public radio. I've been in the field since I was 16. And from the start, I was taught to offer people content that will inform and enlighten. This podcast is dedicated to spreading ideas that speak to the highest part of our listeners rather than the lowest common denominator. If you like what you hear, we're asking for your help. Please leave us a kind review on iTunes so others can find us. You can also follow us on Facebook and Twitter. Thanks. Humankind is produced in association with WGBH Boston and supported by the Humankind Program Fund.
My job, and I've been very vocal about this, is to zealously represent my client. And if that means that I need additional time or our lawyers need additional time, we need to be provided that time. It's not about widgets getting through a system.
How our overloaded system of public defenders risks compromising justice for low-income clients. You're listening to Humankind. I'm David Freudberg. Here's a stunning fact. By age 23, nearly 1 in 3 Americans will be arrested. Often it's for a low-level offense, but what happens to people who manage to get caught up in the court system? For Bill Ward, a teenager in Illinois in the 1970s, the experience ended up shaping his career as an attorney.
My mom wouldn't like me saying this, but the ultimate reason is I was arrested in 1979 on a charge that was not only unfounded, but was inappropriately assessed against me. I had to quit college at the time. I hired a lawyer to represent me. The case was ultimately dismissed, but I had the resources in order to contract with a lawyer to represent me. And that lawyer luckily took a payment and an installment plan and quit college and started working construction. I thought that I wanted to be a lawyer. In '79, I was not quite 19 at that point, but ultimately chose that's the profession I wanted. But I knew at that time, when I was faced with that, I watched in court in Markham, Illinois, in Cook County, just the throngs of people and folks who were asking for someone to represent them. They knew they had the right. They applied for a lawyer. And I wondered what it is that we do as a state or a county to help those folks out, and that was the driving force for me.
Would you be comfortable in describing what the charge was?
Unlawful use of weapon and possession of stolen property. And the unlawful use of weapon was a souvenir baseball bat that was found underneath the seat of my truck, and the possession of stolen property was a friend of mine's driver's license that was found underneath the seat of my truck. And they called my friend up and said, "Did you know that Bill Ward had your driver's license?" He said no. And I was charged with possession of stolen property. And when they found the souvenir baseball bat, when he opened the door and found that, he ordered me out of the car with his gun drawn and me on the side of the road in Flossmoor, Illinois, and said that this is a weapon, and stand up, spread eagle against the car, had me drop my pants to search me for other weapons. And next thing I knew, I was in jail in Flossmoor, Illinois. Is
possession of a baseball bat typically deemed possession of a weapon?
I would think not. I have no idea why that happened. I couldn't begin to tell you, other than I had long hair and I was driving a pickup truck in Flossmoor, Illinois, and ultimately pulled over for a reason that was way back when, that you're supposed to have safety stickers on your truck to pass a safety examination for the truck to be legally operating on the streets. How he saw that from his vantage point, and to this day I'll never know. But that's how the whole process started, and ended up in jail.
Although Bill Ward managed to obtain a lawyer, not everyone has the wherewithal to do so. Fans of police dramas have heard the Miranda recitation: "You have the right to remain silent. If you cannot afford an attorney, one will be appointed for you." But in practice, things aren't always as straightforward as that. For one thing, it's not uncommon for defendants to languish behind bars for weeks before even meeting their attorney. And for many indigent defendants, the lawyer they have access to has a crushing caseload. Bill Ward, now in Minneapolis, remembers.
It was dumbfounding to me as to how as a person being accused, how these folks ever felt that they were being heard, or any way the lawyer could remember their case, let alone their name. And invariably, in the days I was there, people would come in, I'm looking for, and they'd shout out a name. Somebody'd raise their hand, and they'd walk them out, outside into the hallway and they would find a conference room to talk to people. But it was so, it was like going to the DMV and pulling a number and trying to get your driver's license. Very, very impersonal, very a poor lack of communication, certainly not a client-centered way of doing things, in my opinion at that time.
Today, Bill Ward serves as the Minnesota State Public Defender, a public agency of more than 400 attorneys who represent low-income defendants. The right to an attorney if you can't afford one was established in 1963 by the U.S. Supreme Court. It involved the trial of a Florida man named Clarence Earl Gideon, who stood accused of breaking and entering a pool hall with intent to commit petty larceny. He was portrayed by Henry Fonda in the 1980 film Gideon's Trumpet.
Bench ready?
I'm not ready, Your Honor.
Why aren't you ready?
I don't have a lawyer.
Why not? Didn't you know your case was set for trial today?
Yes, sir, I knew.
Why then did you not secure counsel and be prepared to go to trial?
I don't have the money. I don't have any money.
Gideon was a promise based upon a premise, but there was never a funding mechanism put into place. We were told that you had to provide these lawyers initially for felony cases, then of course misdemeanor, and we have gross misdemeanors here, and then for juvenile. But there was never a funding mechanism. It was left to the states. So without a federal government oversight, and there are those who say we're tired of the government telling us how to do things, but without that oversight, we left it to the states to provide for a constitutionally guaranteed right. Clearly we've been described as the bastard stepchild that nobody really cared about, and we were never really good at advocating on our behalf. I mean, certainly initially we're getting much, much better. But that, I think, has been part of the reason and part of the problem over time.
Our system of public defenders is widely regarded as malnourished due to inadequate funding. On the 50th anniversary of the Gideon decision, Eric Holder, then U.S. Attorney General, pronounced the system to be in a state of crisis. In other words, that the right to a fair trial, as guaranteed by the Constitution's Sixth Amendment, is under siege. The problem is more complex than money.
Even in jury selection, the court, the judge informs that just because a person's sitting in court here in trial doesn't mean that they're guilty of the case. They're presumed innocent. I think and I'm sure you have, but certainly all of us that do this work in many, many different social functions, why do you do what you do for a living? Why would you represent those people? And literally I'm putting those people in quotes. There is this presumption that if they've been charged, that they've done the crime. So there is then this bias or the stereotypical belief that they shouldn't have any assistance, that they're the ones who made their bed, they have to sleep in it, that sort of attitude.
Many people accused of crimes are in fact guilty, but the whole point of our justice system is to sort out who's innocent and who's not. Attorney Ezekiel Edwards in New York directs the Criminal Law Reform Project of the American Civil Liberties Union.
We see time and time again the presumption of innocence turned on its head in many of our courts when the defendants are poor, and particularly when they're people of color and charged with crimes. And so when it comes to deciding whether to release somebody pending trial where they are still presumed innocent, overwhelmingly, courts decide to hold and detain people unnecessarily. Our pretrial unconvicted jail population would make us the fourth largest prison population alone in the world. We have hundreds of thousands of people sitting in jails unconvicted. And so if that's not evidence that we don't practice the presumption of innocence that we preach, I don't know what is. I think there are certain people in certain places who retain that cloak of innocence. I think people who come into court with private counsel who is well equipped to focus on their case and make all necessary and persuasive arguments and motions, I think that person's presumption of innocence gets respected far more than what we see in most of the criminal courts, from Baltimore to Ferguson, from Fresno, California to Idaho.
I suppose the most egregious injustice would be for an indigent defendant to be wrongly convicted when they're in fact innocent for lack of adequate legal representation. How often does wrongful conviction happen in the United States in the case of indigent defendants?
Well, we first certainly know that wrongful conviction happens far more than anyone wants to recognize. The fantastic work of the Innocence Project has documented hundreds of cases just through DNA evidence alone. And of course, many cases do not have the benefit of DNA evidence, where people have been wrongfully convicted, wrongfully sentenced to death. In many of those cases, when they look back at what possibly went wrong, although there are often a number of factors, one consistent factor is that the lawyers at the trial level were inadequate, insufficient, and did a woeful job of establishing reasonable doubt, let alone the person's innocence at trial. So that's one of the more egregious examples of the harm. But I would add that there are many other harms that result from not having access to meaningful counsel. If you have a lawyer at your first appearance making persuasive arguments for why you should be released pre-trial, you are much more likely to be released. The harms of pretrial detention, losing your job, losing parental rights over your children, losing housing, are astronomical. It also will have significant impact on the ultimate outcome of your case. So having a lawyer who can, not only at your first appearance, but throughout the case, argue for your release, let alone investigate the case, talk to witnesses, prep you on what's happening, talk to the client about strategy, and then be competent at trial, call experts, makes a world of difference to both whether that person stays in and the ultimate outcome. And so while the innocence cases are, I think, the most egregious example of what can happen when people spend decades in prison for crimes they didn't commit because they didn't have competent counsel, there are people languishing in our jails pre-trial simply because there's no one advocating for their release. There's no one challenging the evidence against them. There's no one plea bargaining with prosecutors. And that happens at a clip of thousands of times every day across the country, and is really as big a concern and as significant a harm in totality as the fact of, let's say, wrongful convictions that we may sometimes hear about.
The consequences of these conditions can be dire. A 2014 study calculated that 1 in 25 defendants sentenced to death in the U.S. is later shown to be innocent. Wrongful conviction also means the guilty party goes free. Minnesota Public Defender Bill Ward.
The American Bar Association recommends no more than 150 felony cases a year. Well,
per lawyer?
Per lawyer. A felony case could be from a murder down to a felony theft or a felony DWI. So 150 of those cases a year. If you look at, on average, maybe people are working 1,900 hours a year, and that's I'm talking about 8-hour days, without much in the way of vacation or sick days, or just talking about holidays and weekends off. 8-hour days, that breaks down to 12 and a half hours per felony case. And that to me is not adequate. If you came to me and said, hey, I'm in trouble, this is the felony charge, and I told you, you know what, I can do what you can, but the best I can do for you is 12 and a half hours. Really, what does that say?
And does that include time spent in court?
Yeah, it includes, that's 1,900 hours work hours a year, and if it's 150 cases, and that's the ABA standard. So
and that does not take into account the extensive need to investigate these cases.
Trial preparation, trial, omnibus hearings, pretrial motions, research, writing, client communication, jail visits, being on the road here. So many of our lawyers travel from county to county to different courthouses because so much of the state is very rural. Jail visits that are 30 miles, 40 miles, 50 miles away, it doesn't account for any of that. So ultimately, those standards are incredibly difficult to meet, and we're not even at 65% of what those standards are. And I think it's just a better way for all of us to look at the hours that are necessary to do, not an adequate job or an effective job. I want, and I know our lawyers, all of our staff wants to be zealous advocates. 12 and a half hours per felony case doesn't cut it. 4.5 hours per misdemeanor case doesn't cut it. So,
and these days, forensic science has become so advanced and complex that there's many additional hours of staff time to kind of meet those needs.
It's an enormous issue for us. I mean, again, when these standards came about is a couple of decades ago, and our own board adopted these standards in the 90s. But, I mean, as you just mentioned, think about how different the practice of law has become for the criminal defense practitioner. DNA went from something that people didn't understand or trust to now they trust it, but ultimately there are advances in DNA that are based upon certain, theoretically, certainly based upon certain scientific methodology. But who's making those determinations?
We're examining the constitutional right to a fair trial in America and the ability to be competently represented by an attorney, even if you can't afford one. You're listening to Humankind. I'm David Freudberg. For more information on this segment, Defending the Poor, and to obtain or download an audio copy, please visit humanmedia.org. Ezekiel Edwards of the National ACLU.
When we have done investigations or our affiliates in states around the country, we have consistently found this problem. And so this is not relegated to one pocket of the country. It's not relegated to one part of a given state. It is something that we have found throughout many states and throughout all of those states. And so, again, whether we have looked at the West Coast with Washington and California with reports that have been out in Nevada and Utah documenting that in court after court, poor people are not receiving their Sixth Amendment rights. If you go down and look at our lawsuits in Mississippi and Louisiana, lawsuits in Georgia, if you look at Pennsylvania, New York, Michigan, if you look at problems as documented in Missouri, this is happening everywhere. And if you think of how many courts there are in all of those states and the number of people we process, millions of people every year charged with misdemeanor offenses, if you think about the fact that we have almost 500,000 people sitting in jail, many of whom, over 2/3 of whom are pretrial, you get a sense of the impact that the failure to provide indigent defense is having. So it's happening in terms of the number of people affected, hundreds of thousands, and I would say tens of thousands every day. And truth is, if you were to, let's say, go to Mississippi and walk into their municipal courts or walk into the municipal courts or magistrate courts of South Carolina, you will see people who are getting charged and prosecuted for criminal offenses that will give them criminal records that will stay with them for the rest of their lives with a range of harmful collateral consequences, who do not have the benefit of counsel. And if it's that easy to find, it's I think a telling sign of how pervasive the problem is.
All right, let's talk about the workload carried by these public defenders who, from what you're saying, are in many, many cases overloaded. What toll does that take on the public defenders themselves, the lawyers, when they are so excessively overburdened?
I think having excessive caseloads and being consistently and chronically underfunded takes a massive toll. Many public defenders go into the work because they want to do justice and they want to represent people zealously. And I think what many of them quickly find is that when you are carrying caseloads of 2, 3, 4, 500 cases, you simply cannot provide the type of representation that you want, let alone that your clients are entitled to. You can't do the investigation. You can't hire experts. You can't spend time with them that you want. And that is incredibly demoralizing and deflating because case outcomes tend to become quite predictable, and it's not a good feeling. I think certainly many conscious and well-meaning public defenders recognize that they are not providing the kind of representation that they would want and that they would want their family members to receive. And it's why one of the problems in public defender offices where they exist is very high turnover, because that operating under that kind of pressure, caseload, and I think kind of sense of guilt is a reason that many people don't stay at the job.
I've had lawyers in my office crying, about they just can't do this anymore. The stress, the birthdays that have been missed, the vacations they haven't taken, not taking off sick days because the case was set for a sentencing or they have a trial that's set. It takes a huge personal toll. I mean, anybody who says it doesn't, I think, is lying to you a little bit.
The reason most public defenders put up with difficult working conditions is that they're true believers in fair play, ensuring a level playing field for their low-income clients. Because in some ways, the odds can be significantly in favor of the prosecution, armed with its considerably greater resources. Bill Ward.
I mean, if you look at national or statewide studies, it's billions more monies towards prosecution of offenses versus towards public defense or public defender jurisdiction and agencies. There's absolutely no comparison. I know a lot of county attorneys who will say, well, we also represent the cities or municipalities, so we have lawyers assigned to those sorts of cases. There's no comparison between the two. And what many people, and this is on us too, fail to recognize is that when a case comes in, it's not just the county attorney's office or the state's attorney's office or DA, depending on your jurisdiction. They also have the sheriff's police who can do investigations. The state police do investigations. Local police. They have all sorts of resources. The Bureau of Criminal Apprehension. I mean, there are so many different arms that they can use and utilize in the prosecution of a case that we don't have. Now, and I'll put it in perspective. Our last calendar year, we were appointed to approximately 145,000 cases in this state. 145,000 cases. Now, mind you, I told you we have on the district court level just over 400 lawyers. 145,000 cases. I have 44 investigators for 145,000 cases. Think of how many thousands of police officers and other investigators that before the case is even thought about charging, the investigation is done beforehand, then they get it here and all of a sudden we're provided a complaint and the discovery. Well, here's the charge. What do you want to do on it? 145,000 cases, 44 investigators. And I think that is the best way of kind of understanding the disparity, how under-resourced we actually are, and to do our due diligence in representing our clients.
Which will have the effect of only compounding the burden on this office.
And compounding the cost to the state. Right? It's so much more cost efficient to spend the money up front than sending people to prison and the daily costs of prison and all that entails, or people languishing in jails. I call it McJustice. It's meet 'em and plead 'em, and it's a culture change that we are, as public defenders, are guilty of participating in. But we have changed our culture in our agency, that we are not just going to stand by and just be a part of this machinery that just it's meet and greet and meet and plead and move on.
And by that you mean that an actual deep understanding of a client's case, doesn't develop because it's such a almost factory-like process.
Absolutely. It's about the criminal court system understanding that our clients are human beings, that we need to treat them with dignity and respect. It's not just about due process, it's about procedural fairness, that they feel that they are being heard. Too often, our clients, understandably so, come in and say, it's the public pretender, right? It's the penitentiary deliverer. They don't care about me. You're just paid by the state. And, you know, if I'm being appointed a lawyer in the criminal court system, I don't blame them for that, because it's a lack of trust. And it's our job to make sure we work with the client, communicate with the client, take the time that we need to explain what's going on to the client, return phone calls, go to the jail. And unless we do that, the client, rightfully so, feels that their voice wasn't heard. So, you know, ultimately, do they feel they've gotten a fair shake? And
so they, in effect, because you're the closest
absolutely
representative to them, they end up blaming you.
Right. And compound that with how many individuals are in jails now with mental health issues that, we have so many folks that we work with that are good at masking any mental health issue, because it's not something they want to be known. They don't want to be caught up in a system where they'll be evaluated for competency or other mental health issues. And if we don't spend time with them, enough time with them, we're not really going to see or understand deep down. We're not taking the time, or we don't have the time to ask the right questions. So it's impossible really to get through the layers of individuals to truly understand, why they're in the system in the first place. Is it housing issues that we can be addressing? Is it mental health issues, drug and alcohol issues? And all of us need to do a better job at addressing that. Otherwise, unfortunately, our citizens are going to keep coming back and forth. But there are so many other things that can be done. You know, we have cases that shouldn't be misdemeanors, that should be petty cases. Certainly, we took a beginning step on what's been described as a historical approach to our drug laws in Minnesota.
So, do you see decriminalizing of certain offenses as a key part of fixing this?
Without doubt. And that's just not me. That's study after study about whether it's the new Jim Crow, which is, I think, a very apt description as to what's going on in not just our state, but in the United States. If you really truly look at the laws, once someone is in this system, it's so difficult to get out, to extricate yourself from the tentacles of the criminal court system. Fines and fees and obligations. How long are you on probation? Can that probation be extended? What are the conditions under probation? How much do you have to pay to get through alcohol or drug treatment? And then just inundate them with additional fines and costs. And it becomes a system where only the wealthy or the people of moderate means can get away from the tentacles. And people who are impoverished are forever stuck in the system.
Bill Ward, Minnesota State Public Defender in Minneapolis. We also heard from Ezekiel Edwards in New York, director of the Criminal Law Reform Project at the American Civil Liberties Union. You're listening to Humankind. I'm David Freudberg. Studio recording by Doug Sugarts. Editorial assistance from David Cruz, Ken Rogers, Kathy Graham, and Mark Hilstein. Webmaster Brian K. Johnson. Special thanks to David Carroll, Daniel Kolb, Jeffrey Burkhardt, and Tony Buck. Our program is presented by Human Media in association with Connie Goldman Productions. Program development provided by Shart Media.
To purchase a CD copy of this program, please call 1-800-5LISTEN. That's 1-800-5LISTEN. Or visit our website, where you can also obtain an audio download of this and our other programs and can hear selected episodes free. You can access free written materials related to this program as well. Our web address is humanmedia.org. Again, if you'd like to purchase a CD copy of Humankind by phone, please call 1-800-5LISTEN, and our web address is humanmedia.org.
And you can subscribe at iTunes to our free weekly podcast, Humankind on Public Radio. This segment, Defending the Poor, is Humankind program number 252.
The executive producer is David Freudberg. This is Humankind.
To hear more episodes of Humankind, you can subscribe to our free podcast on iTunes, Stitcher, or your preferred podcast player. A new episode each week. The podcast title is Humankind on Public Radio. And if you enjoy this program, be sure to leave us a kind review at iTunes and Stitcher. If you want to support the program, please visit humanmedia.org. And at the top of the homepage, click on How You Can Help. Again, our web address is humanmedia.org. Thanks.